Hello and welcome to Defending the Windy City with David Drwencke. I am your host, Kevin Rosenquist, and today we explore the unique approach DRD law brings to the courtroom. We're going to discuss what makes attorney Drwencke different from other attorneys and how his strategies in court give his clients a distinct advantage. From his preparation techniques to his courtroom presence, David has earned a reputation for getting results. David, welcome back. Great to see you.
Absolutely. Great place to be. Good to see you.
Before becoming an attorney, you had experiences and training that influenced your approach to trial. Can you walk us through your background and how it shaped your strategy?
Absolutely. And I think this is a unique background that separates me from a lot of my colleagues and peers. It's that many of us, when we know we want to go to law school, maybe we do an internship, maybe we'll follow an attorney around, or we will do a summer program while we're in law school for those 3 years, that's our first experience being in the courtroom and learning from attorneys and so forth. Otherwise, it's what you learn in the classroom and after you graduate. Well, I had the benefit of actually being a judicial law clerk for 7 years in Oakland County, Michigan, for a very busy trial judge. I mean, he liked being in trial so much that if we weren't already scheduled to be in trial, we were calling other courtrooms to see if we could take their trials, or if they were double booked, could we take their stuff? He wanted to be in trial, Judge Nichols, who I don't chat with a great deal, but I still catch up with every now and then. So I was watching trials nearly every week, both good and bad attorneys, both civil and criminal, but I got exposed to hundreds of trials. And because I'd been there for so long, I could speak to the attorneys and ask them, well, why did you do this? Or why didn't you do that? Kind of armchair quarterbacking it a little bit. And they would tell me why. They were, happy to explain their process and their techniques and so forth, because I was the wannabe attorney. I was in my 20s and so forth, and they like to impart the knowledge. The other most valuable part of my job is because I worked for the judge. I wasn't a prosecutor. I wasn't a defense attorney. I was unbiased third party, and I was uninvolved in the case, was that I could speak to the jury members. Now, usually I was handling them going in and out of court. I would actually go and retrieve the notes during trial to go and give to the judge and so forth. But it was after trial. A verdict would be rendered, good or bad, guilty, not guilty, in favor of the plaintiff or defendant is a civil case. And I could then talk to the jury members and ask them, like, well, what did you think? What worked here? What stood out? Why did you ultimately rule the way that you ruled, or found guilty or not guilty? And I'd get really long, honest answers. And they'd be talking about the presence of the attorneys and the presentations of the attorneys and their style and the way they came off, or facts that, as I'm watching the trial, I took one way. I thought this was important and that was important, only to find out the jury viewed it 180 degrees totally the other way. Yeah. And like, wow, this is amazing. So I got all this feedback over years and years and years, and you'd start to learn some themes from this of what really kind of resonated and worked and what didn't. And I put that pen to paper, and I have a notebook on those notes. But what I thought was most interesting is after I'd get these really long, very honest, candid answers from jury members, the attorneys would want to come in. And the jury members didn't have to stay. They oftentimes did. And the attorneys would come in and ask, hey, do you have any feedback for me? How did you think I did? What did you think was important? And it would always be canned. Like, you both did a really nice job. Good job. Have a good rest of the day. The facts were the facts. And the end. You never learned anything from the jury members when you were the attorney. But as the clerk, I got every juicy little detail. I got everything about how much they hated one of the attorneys because the way they were behaving in court, or the way that they would repeat questions, or whatever, multiple things. That experience, being in the trial court as long as I was, seeing as many trials as I had seen, being around the attorneys, and then the big one, speaking to jury members, is invaluable. I mean, that experience basically compressed more than a career's worth of actual trial experience for many of my colleagues. We'll talk about, like, well, I've participated in 100 trials in my 40-year career. It's like, I've participated and seen hundreds of trials, and I'm, much earlier in my career. I'm 40 years old, not 40 years into my career. And it's super beneficial. It gives me a leg up on any other attorney. I don't care how long they've been at it. They haven't been through more trials and seen more trials and gotten into the experience of talking to jury members like I have, because of those 7 years as a judicial law clerk.
How has your approach evolved over the years?
Sure. There's what I thought I knew. Again, doing that armchair quarterbacking, and as a clerk, it's like, well, I would do this or I would do that, and I really thought it was about just my own personality. It's like, well, I'm the authority in the room. I'm Mr. Persuasive. Just listen to me. I'm going to walk on water and win cases. And while there maybe were times where just the personality went a long way, the jury liked me. So they chose to listen to my version of the events more than the state's attorney because he or she was a little more rough around the edges or not as friendly or what have you. At the end of the day, jurors and the judge at a bench trial, they have one job to do. They're to apply the evidence as presented, and it usually comes in two forms. It's going to be testimonial evidence, people who come in and testify from the witness stand, and then exhibits that come, photos and videos and admitted exhibits as evidence. That's what they make their decision on, and they take it deathly seriously. I've never had the experience where I thought a jury blew it off and didn't care and came back in 30 seconds with a verdict and didn't look at anything. To the contrary, I actually sometimes believe they may take it too seriously, and that can hurt a client where they're overanalyzing to the point to help the state as opposed to overanalyzing to help the defense. Probably the single biggest thing that changed my approach was reading a book, and I actually don't want to share it because I don't want the state's attorney getting a hold of it. And in fact, I had to sign an authorization form, among other things, like stating I've never been a prosecutor. I'm not going to be a prosecutor. I'm not going to use these techniques and approaches for the benefit of the state. This is for defense attorneys. But as a general proposition, it was written by a psychologist, not by a practicing attorney. Now, this psychologist worked with attorneys, and the big point that he makes is that it came from doing years and years of jury research and learning about, again, what would sway the jury, what worked and what didn't work, the psychology of a juror in a criminal case. And the big takeaway, there are many, and I think it's the most brilliant book that I've ever read, and I apply these principles in every case, and they've been successful, but it's focusing on the fact that in a criminal case, the state or the prosecutor, they have the burden of proof. That's it. They've made an allegation. Now they have to prove it in order to have my client or the defendant found guilty. Where a lot of defense attorneys get themselves into trouble is kind of letting the state off the hook by saying, well, we're going to show you what really happened. Here's our evidence.
That's interesting.
And now it becomes this battle of, well, the state says it's this, and they have all the witnesses, because more often than not, the defense might have their client, maybe one or two other witnesses. Maybe they have some of their own evidence. It's rare, but maybe they do. So you have the state with all their detectives, all the evidence techs, the people from the Illinois State Police Crime Lab, witness after witness after witness. They're the ones who put on all this evidence. But the defense said, well, they're going to show what really happened, and they called one witness. So there's a total unbalancing there between the two sides, and the defense starts to accept a burden. It's like, well, I don't necessarily accept what the state told me, but I don't really accept what the defense told me either. And so now I'm going to pick which one I like better.
Now I have to choose one. Yeah,
absolutely. And they're going to pick the state, and the statistics bear out. I mean, it can depend on the type of case and the jurisdiction, but the most recent statistics that I've looked at is that the trial victory rate for the state is in the high 90s. We're talking 95% and above. The most recent one I saw in Cook County is 98% that the state wins at trial. And now, why is it? It's because 98% of people are guilty. Now, the state would say yes, like that's why. Why do I think it is? Because jurors are afraid that, they don't want to be wrong, which is laudable, but they also are afraid of letting somebody who's been charged with a violent offense or a sex offense or running around with a gun or drugs. It's like, I don't know. I think he did it. There's some smoke here. If I'm going to err, I'm going to err to saying guilty, because the state's presented this evidence. They say he's guilty. There must be something here. Where all of that thinking, where there's smoke, there's fire, or I think he did it, or he might have done it. So none of that is sufficient.
Right. It shouldn't be. Yeah.
Absolutely. And it's educating the jury on that and then wording it a little bit differently. I'm not allowed to define reasonable doubt. I can't say, well, you have to be 99% certain. I'm not allowed to even make that argument pursuant to Illinois rules and case law. But I can, because it's a fair way of wording it, is the state has a proposition. It's guilty or not guilty. When you're looking at a verdict form, it's not guilty or innocent. It's not he definitely didn't do it or he definitely did. It's not that binary. It's State, did you meet your burden beyond a reasonable doubt? Did you prove this? It's proven or not proven. If they haven't proven it, the appropriate verdict is not guilty. And again, that's not, I've said this in closing, it's not you think my client's the best guy and you want to go grab a beer with him after this and you guys are going to be friends, or, that there's no evidence. I'm not going to insult you. There are some people who say my client's involved in this. I have reason to believe that they may be lying or they're exaggerating, among other things. I'm telling you or asking you, jurors, put the state's theory through this prism of beyond a reasonable doubt. And if you're not satisfied beyond that, if they haven't proven it to you, then the only verdict is not guilty. And that, I think, allows jurors to feel more confident in making that decision, saying, you know what, there's something going on here. Like, I'm certain something happened. I just don't know what that is. And these are the rules. We're in a court of law, not on the side of the street where we want to believe people and so forth, that this is the appropriate verdict. You didn't meet your burden, the end, and move on with your life, because that's the task that we ask jurors. And that's what we'll hear from judges. That's what, in fact, why I like bench trials a lot of times, because the judge doesn't overanalyze. It's met your burden, didn't meet your burden, the end. And they move on with their life. There's not a lot of hand wringing. That's exactly how they'll word it. State, you didn't meet your burden, not guilty. The end. We move on. No further explanation needed.
Yeah, and what you were saying before, like some people were like, "Well, this was a violent crime he's being accused of. We want to keep this person off the street." But also, this flip side of that is, what an awful thing to be falsely imprisoned for a violent crime you didn't commit. I mean, that's like, you got to be sure if you're going to send someone away. Well,
absolutely. And again, while unfortunately I'm not allowed to argue it this way either,
right.
It's the conversation I will have with people either on the street or, like cocktail kind of conversation. Somebody will find out, oh, David, you're a criminal defense attorney. Like, how do you represent people charged with murder or, sex offense and so forth? And what I've kind of put together as an argument or a way of phrasing it is, well, I'm going to tell you the facts of a case. I'll lay it out for them and be as honest as I can be. Like, these are the facts. These are the allegations. This is the evidence. If this was your father or your husband or your son or an uncle or some family, somebody you love, and I'm telling you, this is the evidence, would you be satisfied that a jury found him guilty and now he's going to, perhaps spend the rest of his life in prison, or he's going to be marked as a sex offender, or among other things, that he's going to suffer a very serious consequence? And that's when you'll actually kind of see go over their face and they'll say, ooh, well, think of it that way. You're right. No, I would not like that very much if that was my husband or so forth. Now, of course, put them in, what if it was you? How would you feel that you're facing going to prison? And this is the only evidence that there is. If somebody says you did it with not an ounce of corroboration. And again, that way of thinking about it, putting in the appropriate context, makes a big difference. Now, again, like I said, I can't actually word it exactly that way before a jury. I can't say, pretend that my client is your brother. Would you convict your brother? I would love to, because I think it'd be very persuasive.
It'd be very impressive. Yeah, that would work.
But I'm not allowed to do that, unfortunately.
Probably for good reason.
But there's, and I understand that. I don't, I'm going to abide by the rules, but it's jury education is a big part. Like, what is reasonable doubt without defining it exactly, and then allowing them to feel comfortable saying not guilty just means not proven, and we move on. And like, that's the way the system is supposed to work. Like, it is supposed to be difficult for the state. Well, if this burden is so high, it is supposed to be so difficult, why is the conviction rate 98%? It's like, because defense attorneys are doing a very poor job of defending their clients and educating the jury and holding the state to that burden beyond a reasonable doubt.
Speaking of juries, how do you approach jury selection? Without giving away trade secrets, are there specific techniques or strategies that you use to ensure the jury is what you want out there?
There certainly are. There's strategies. There's some psychology that's involved with this. There's creating, within reason, the type of juror that you would want for the type of case that you're talking about. What are the facts? And because that can change. Different cases your model juror will change. Yeah, without necessarily having to get too much into the weeds, the idea is, if I have a client who's facing a sex assault case, so I have a male client charged, and it's really he said, she said, the allegation is that you sexually assaulted somebody, and that's it. There's no DNA, there's no witnesses, there's no video, there's nothing else. It's like, well, okay, who's most likely to be able to put themselves either intentionally or unintentionally into the shoes of the defendant? It's like, well, probably a male around his age, or somebody even older, being like, well, yeah, albeit but the grace of God, like, I would be in his shoes here. And there's a level of empathy there that I want them to have, that it's like, listen, this evidence better be persuasive and better meet that burden, because I'm going to say not guilty because this is crazy. This could be me, like this is easy to see myself in those shoes. Now, not all cases are that kind of cut and dry where I can say, well, yeah, I want a male in their 30s or 40s because they're going to empathize with my client. Murder cases and gun possessions and what have you, it's like, well, gender starts to matter a lot less. What we're really looking for then is just somebody who will be fair. That's the foundation. Put to both sides. Hear both sides and make your judgment. We want you to then make your ruling. So how I'll explain it to clients is that there's an awful lot more art than science, though there are scientific principles, psychological principles. Again, this model juror that we put together is of who we think we would want, who do we think would be more empathetic or open-minded to our defense and hear us out and give us a fair shake at trial. I have that going in. Now, sometimes it's as simple as just a gut feeling. And I will tell my clients that we only have a handful of what are called peremptory challenges, where within reason, I can kick a juror basically for any reason. I don't like the tie they're wearing. I don't like the way they looked at me. I just thank and excuse and they're gone. Those are limited. So I have to be judicious with those people I'm kicking. Now, then there are challenges for cause. It's effectively unlimited. If people come up and just say, I can't be fair, I'm racist. I think everybody who's charged with a crime is automatically guilty. I suffered this crime. That oftentimes will happen again. It's like, I was sexually assaulted. This is a sexual assault case. I can't be fair to this defendant. Well, as soon as they use words kind of sort of like that, I can be in front of the judge and say, Your Honor, I'd like to excuse juror number, whatever the number is, for cause. They've let it be known that they can't hear out the defendant. They can't be fair in this case, and they'll be excused. Well, again, as many people say things like that, they can be excused for many reasons for cause. The peremptories are where, again, the art comes in, where I can kick them. I don't have to explain my reason. I'm just kicking them because I don't think they're my juror. But I'll share that with my clients. Like, listen, if somebody's kind of giving you a side eye, or you've got an uncomfortable feeling with this individual, let me know. Write down notes. And it can be as simple as just a gut feeling. I don't like the way that he or she is looking at me. It's unfortunate that in Cook County during jury selection, there's a kind of a broad term just called voir dire. That's where we would otherwise question jurors to learn more about them. In Cook County, it's usually judge-led. Very little time for me to get up in front of the jury to ask my own questions or really to rapport, which I have my own philosophical take. I think that is not really appropriate. I think there should be a lot more attorney-led voir dire, because
that's usually how it is in the movies. It's always attorney-led that I've seen.
Absolutely. And actually, ironically enough, for attorneys, for criminal defense attorneys specifically, if you're looking for, well, I want to get better at my craft, I want to learn more, I want to go to a trial college, or I want to go to some seminar, what I found, because I've gone to many of them, I think it's interesting, I want to be as good as I can be, is that a disproportionate amount, 75% of the time, 80-90% of the time is spent on, well, voir dire. Your case can be won in voir dire and picking the right juror. And I then lean back in my chair and go, I actually don't disagree with you, but I don't get to do any of this stuff. So your techniques and tricks and what have you, like, great info, I get to leverage none of this because I don't get to
use this at all. Yeah.
So it's learning the questions that the judge will ask. And there's a lot of stock ones that we will expect, but you'll learn about, how old are they? How are they employed? Their spouse, if they're married, if they have children, and they'll ask, have you ever been charged with an offense? Have you ever been a victim of a crime? Have you had a close family member who's been a victim of a crime? There are things that we can learn. And then oftentimes jurors are very deliberate in bringing things to try to tell us something. Like, I will pay close attention to what books the jurors will be walking in with, because I feel like that is, if not 100% intentional, it's very close to intentional that you brought in this kind of politically motivated book. It's like, you're telling me something about yourself. I feel like you're doing it on purpose because
you don't want to be on the jury.
Yeah, you're doing this, and like, that's fine, but like, thank you for doing that, because now I've learned something about you. It's when somebody walks in, it's like, nope, no book, no other tip off. I know they're 40 years old and a computer engineer. They've never been in trouble. They've never faced a case. They've never been in court. And you're sitting there going, I know their job and how old they are. Like, that's it. I don't have much more that I can go off of other than stereotypes and things that you think about somebody who handles that job and what somebody's like and they're at that point in their life at being 40 years old. That's about it.
And that's not great information to go on. Like,
not a lot.
Stereotypes and stuff like that are generally not what you want to try to go for.
Exactly right, because there's always exceptions to the rules,
Yep.
and what you think you know about that person, or what you would assume the stereotype would be. It's like, oh, but you're not that person. It's
Right.
like, that
We've
would have
all
been
been
nice to
guilty of
know.
that just in everyday life, of assuming something about somebody because of something and then realizing, oh, wow, I could have been more wrong about that.
That's exactly right.
Yeah. All right. Well, thank you for joining us on Defending the Windy City with attorney David R. Drwencke. To connect with David, head to drdlawllc.com. And don't forget to like and subscribe to our channel and leave us a review. David, it's always great to chat with you. Thanks so much for being here.
Thanks for having me.